Hi, this is John Leonard. I'm a lawyer with Fairfield and Woods in Denver, Colorado. Today we get to talk to one of my colleagues, Courtney Kelly. She's an estate planning lawyer and nonprofit organization attorney. Today we're talking on the estate planning side. We're going to talk about guardianships and conservatorships. Thanks for joining us today, Courtney.
Thanks for having me, John.
So I guess I use the terms interchangeably, but what is a guardianship and a conservatorship? What are they and what's the difference?
Sure. So a guardianship is a court proceeding where somebody would file a petition for guardianship over an individual who they believe is incapacitated or is suffering from some sort of problem where they need somebody else to make decisions for them. These are the types of decisions that have to do with medical decisions, where somebody lives, and then sometimes the guardianship court will also give the guardian some control over the finances as long as the finances are minimal. A conservatorship is a similar court proceeding, but it has to do with managing somebody's finances. And I think everyone now is aware of the very famous conservatorship case of Britney Spears. And that has become quite a topic of discussion in the media and possibly an example of how a conservatorship can go wrong or can last too long when somebody's disability.
We could do a whole presentation on the rock and roll or country music conservatorship gone bad. So, well, when is a guardianship or conservatorship necessary? And I guess you already broached the subject. I mean, when should they terminate?
Sure. So there's a variety of situations where a guardianship or conservatorship could be needed. One example is for minor children. So if something happens to the parents and the court needs to appoint a guardian or conservator of that minor child, then they'll go through that process. And then when that child turns 18, then the guardianship or conservatorship will terminate. Another example is if somebody is born with a mental disability and is unable to make medical or financial decisions on their behalf, then generally the parents will go to the court and get a guardianship or conservatorship over somebody. Another example is if somebody is in a car accident or suffers from a mental breakdown and is not able to manage their finances in a responsible way. And for example, let's just say they're walking down the street and giving away money and the family wants to stop that. They can go to court and have that guardianship or conservatorship implemented. And then if it's a disability that goes away or gets better, then the person who's under the conservatorship or guardianship can petition the court to terminate the guardianship or conservatorship.
Well, good to know. Well, so we've talked about the conservatorships and guardianships. Who can serve as a conservator or guardian?
Well, just about anyone can serve as long as they are of age. And, normally for our clients who it's just really it's just a guardianship and maybe there's a little bit of assets, usually it's a family member. If it's a contested matter and there's a lot of money involved, often we will have what's called a third-party independent professional fiduciary service or bank or trust company. They'll come in, like I said, especially if it's a contested situation. For example, if the siblings can't get along and they want a third-party neutral individual to serve, then we have a lot of groups here in Denver, banks, smaller private fiduciary firms that we have used, and they can serve in that role in a professional manner.
Very interesting. Well, Courtney, like a lot of things you do, don't try this at home. Very interesting. Your contact information is on the next slide. Thanks so much for joining us today to talk about guardianships and conservatorships.
Thanks for having me.